Before I start, this works much better if it's interactive, so I'm going to talk through a couple of things that I think is relevant for everybody to think about with regard to their estate planning. But if anything I'm saying doesn't make sense, if you have questions, as I get towards the end, there are things we want to talk about we haven't covered, please interrupt me and ask questions. There's no such thing as a dumb question, so if you're thinking about it, somebody else probably is too. So please ask if you have any questions as we go forward. So as I mentioned, I'm an estate planning attorney. I live here in Wellesley, my office. I live here in Medfield, my office is in Wellesley. And so what I have is a few topics to go over today. These are basic things that everybody should be thinking about, not just the folks in this room, but frankly everybody out there in the world. And I'll go into a little bit of detail on some other topics related to taxes and Medicaid and long-term care. I'm going to try and keep it sort of mile high because there's a lot of information to digest, and so I think it's good just to get a basic flavor of the issue. So to start, so I said, you better start taking your time. So I use the term estate planning, and what does estate planning mean? Estate planning is just a way of organizing your affairs and setting up a set of legal documents that do different things for you to plan for the eventualities of life. If someone gets sick, if somebody passes away, having their affairs organized in a manner so taxes are minimized, there are people named in place to do things for you, assets go where you want them to go, with the least amount of work and disruption and cost, frankly, for your family. So that's, when I say estate planning, that is the objective, to do those things. The first slide I have here, what are the goals of estate planning? And those are really the things that I touched on. Reduce the work that others have to do for you in the future. So the reality of it is every single one of us in the room, myself included, at some point is going to pass away. At some point in life, it's probably going to get sick. It has something happen. To the extent you have done planning in advance, it dramatically reduces the amount of work your loved ones need to do for you when that happens, for which they'll be very grateful. Protecting your property, and I'll talk about that a little bit, from different things, from taxes, from expenses of dealing with illnesses and things of that nature. Reducing taxes. This is mostly estate taxes when I refer to reducing taxes, and frankly, as you'll see when I get to the end of the presentation, almost nobody in this country needs to worry about the estate taxes today. So that's not as much of a concern today, but it's something I did want to touch on briefly. And then ensuring that your wishes are carried out. So not only your wishes about who's going to receive your assets, but your own wishes about things such as medical care. What kind of procedures would you want done? What kind of procedures would you not want done? Things of that nature. So these are the goals of the process. So what if you don't do any estate planning? And I don't have any data for this, but it's my sense that as a general proposition, less than 50% of the people out there in the population have ever bothered to do any estate planning. So if you haven't done it, I sense you're probably in the majority, in my opinion. Why don't people do it? I don't know. They don't want to pay lawyers. They don't want to think about dying. They think they're immortal. Who knows? But for a lot of reasons, people don't do this. And so if you don't do estate planning, a few things. One, it's dramatically more expensive to deal with problems when they come up if you have done no planning than it is to plan proactively and put things in place. I mean, it's multiples. We in my practice deal with both. We help people set things up. We also deal with people who pass away or people that are helping their families work through things. And when people have not done the work up front, it's just much more work on the tail end. So it is dramatically. The other thing is, I always like to say, if you don't plan, the government has a plan for you. It may not be the plan you want. And that's who receives your assets if you pass away. So if you pass away without a will, that's the law calls you intestate, and every state has a law that says if you die without a will, who gets your assets. It's not the government in most cases, in almost all cases. That's sort of a common misperception. But it may not go to the relatives you really have in mind. For example, if it's a second marriage or if there aren't children and things of that nature, the law can sometimes send assets in a way that isn't really what people have in mind. So you want to make sure that things go where you want them to go. And the way to do that is to do some planning up front. So before I get into the specific documents, what is the process? If you decide this is something that you want to do at some point, what would you do? First off, you should find an attorney that you're comfortable with that does this kind of work. There's, I do it, there's lots of other people out there that do it, so find somebody you're comfortable with that you can work with. And then what happens is when clients come in, if it's done right, it really shouldn't be cookie cutter. It's not like someone's going to pull a will off the shelf and write your name on it and you're done with it. It really should be kind of a getting to know you process, getting a good sense of what are your assets, what are your liabilities, who are your family members, who do you want to benefit from your assets, what are the things you're worried about, and sort of getting a sense of all of those things. And then once those issues are there, the lawyer's job is to educate you on your options, what can you do, the issues, a lot of the issues you might have already thought about, but frankly, the thing we hear from clients over and over again is, gee, I never thought about that, gee, I never thought about that. And I always feel good when someone says that, because that tells me I'm doing my job. So our job, again, is to educate people on the issues, present the options for the solutions, and then you decide what it is you want to do. And then the estate planning attorney can help you put a plan together to address those points. So that should be the process, just kind of an overview. So what are the basic estate planning tools? At the end of the day, the product is a set of legal documents that do different things for you. And the basic documents are a will, a trust, a durable power of attorney, a living will with a healthcare proxy, and if you own a home, a declaration of homestead. And I'm going to talk about each of these. But these are the basic tools. Every single person out there should have a will, a power of attorney, and a healthcare proxy, no matter your financial situation. A trust is sort of the next step up the ladder of complexity. For some people that makes sense, for some people they don't. We can talk about that a little bit. The declaration of homestead is something that if you own a home, you should definitely have, and I'll come back and talk about that a little bit. So what is a will? A will is a legal document that you create. It has to be signed in front of two witnesses. It has to be notarized. There are some formalities around it. But you do a few key things in your will. The first thing you do is you name a so-called personal representative of your estate. To me, it's always going to be an executor. This is what most people think of as an executor. For some reason, Massachusetts rewrote all the probate laws last year. As part of that, they changed executor to personal representative. It's the same thing. But it appoints someone to be that. Now, what does an executor do? An executor has a few key responsibilities. When somebody passes away, the executor's main job really is to wrap up somebody's financial life. They go out, they gather up assets, they pay off debts, they file tax returns, the tax returns need to be filed, and then they turn over the assets to whoever you designated to receive them. Typically with a married couple, you would name each other first, and then name a family member or a friend to be the backup executor. If you talk with different lawyers, some lawyers encourage their clients to name an attorney or a professional as an executor. I don't think that's per se wrong. My view of the world is that would not be the way I would recommend to do it, and I don't recommend it to my clients. You want to pick someone to be executor that has a few characteristics. You want someone you trust completely, because they will have their hands on the assets, so you want to make sure they're going to do the right thing. You want someone who's going to be able to understand what they're dealing with. They don't have to be a lawyer, but they need to be sophisticated enough to know the responsibilities they have. And the reality is, executors are going to hire a lawyer of their choice, they're going to hire an accountant, and they're going to work with those professionals who will guide them through the process. So they don't need to know what to do, they just need to know enough to get help. And another key criteria, frankly, is someone who's got the time to do it. Being an executor, I will tell you, every estate I've been involved with, at some point, the person who is the executor says this is a curse. Because it's a huge amount of work. It tends to be a situation where people that aren't the executor oftentimes will be on the sidelines snapping up what they're doing, and they don't actually have all the facts about what's going on, and they sort of have to take that. So it's a big job. But again, those are the key criteria, but it's a very important choice in the estate plan. The next thing you do in the will is you dispose of your assets. And now the will does not control what happens to all of your assets when you pass away. If you think about the kinds of assets people may own, there's a home, bank accounts, cars, retirement accounts, life insurance policies. There's all different kinds of assets. A will does not control what happens to all of the assets. It only controls what happens to what a lawyer would call your probate assets. So what are your probate assets? Your probate assets are assets that you own in your name alone when you pass away that do not have a beneficiary designation on them. So for example, you have a life insurance policy, it's going to have a beneficiary designation. That beneficiary designation and not the will is going to control where that asset goes. If you have a retirement account, an IRA, a 401k, that's going to have a beneficiary designation. That beneficiary designation, not the will, is going to control where that account goes when you pass away. Anything that you own jointly with somebody else, you own your home jointly with your spouse. First one passes away, it's not going to go through probate because it's going to go to the joint owner automatically. So the will controls things that you own in your name alone and that don't have a beneficiary designation. So for example, you have a bank account that's just in your name, that will go through probate. You have a piece of real estate that's just in your name, that will go through probate. You have a car that's just in your name, that will go through probate. So these are the assets the will controls. So when you do your planning, it's really important to make sure the will says what you want it to say in terms of who's going to receive your assets. But then it's critically important that you take the second step and go look at beneficiary designations for any things such as retirement accounts or life insurance to make sure they say the same thing. Any questions on that, on the will? Any of this so far? Making sense, mostly?
Mm-hmm.
Okay. Flip over. So the next item up the ladder of complexity is a trust. And there are many different kinds of trusts. There are revocable trusts, which are free to change at any time. There are irrevocable trusts, which once you create them, you cannot change them. And there's many, many different variations. Trusts serve good purposes for some people. Before I get into why you use them, let's talk about what is a trust. I think there was a time when only the Rockefellers and the Kennedys used trusts. In this day and age, they are very commonly used. And the example I always use for what is a trust may be of interest to some of you who have children or grandchildren, but here's the example I use with all my clients for what a trust is. I have, my oldest son is 14. If I send him off to a baseball game with my brother, and I say, well, you're at the baseball game, and I give my brother money. So I send my brother off to the game with my son. I give my brother a $20 bill. I say, well, the two of you are at the game. If Jack wants a hot dog, you buy him a hot dog. If he wants a soda, you buy him a soda. When the game's over, give me the change. That's a trust. My brother has that money. No one can take it away from him, but it's not his money to use for himself. He's holding on to it for the benefit of my son, and what he can do with it are the things I spelled out. Conceptually, that is all a trust is. And then, lawyers add on 40 pages of legalese to make the thing work, but that's the notion of it. So why would you use a trust? There's a lot of different reasons people use them. Some people with very large estates use them to get around estate taxes. More common uses for trusts, some people use them to avoid probate. So if you have assets, I mentioned there are some assets that would have to go through probate. It's better to avoid probate if you can. There's an expense and a delay involved with it. So a common way to avoid probate is you create a trust. It's a revocable trust. It's a trust you create during life. Anything you put in, you're always free to take back. You'll pay the taxes on the asset in there. You don't get any protection from creditors. It really is just a different name on the asset, the name of this trust. But the benefit is, whatever is in that trust does not need to go through probate when somebody passes away. So the trust says, during my life, do this, upon my death, do that. And it simplifies things. So that's a very common use of a trust. Other times people use trust if they're concerned about children or grandchildren inheriting assets outright. If they're worried that somebody, is a spendthrift, if they get the money, they're going to blow it. Or maybe they're in a bad marriage and they're worried about, geez, if my son gets the money and he gets divorced, it's going to be lost. Whatever the reason may be, if there's a concern about the child or grandchild getting money outright directly, you can leave it in a trust for that person's benefit. And just like my son at the baseball game with my brother, you pick someone who's going to hold on to that money and they'll disperse it as needed for that person, but because it's in the trust, it gets a fair amount of protection. So that's another common reason to use a trust. People use trust sometimes when they're worried about long-term care expenses. I'm going to come back to that at the end of the conversation. Any questions on trusts or? Yes?
You mentioned you pay the taxes if you put it in a trust, so you got to file 2 tax?
So the question is, who pays the taxes on it? So if it's a revocable trust, so if you create the trust to avoid probate or whatever it be, as long as you're alive, no. So that during your life, the trust uses your social security number, this taxpayer ID number. There is no special tax return for it. You simply, let's say you have an account at Bank of America in the name of your trust. They'll issue the 1099s right to you, and you'll just put it on your personal return. When you pass away, all that changes. It becomes its own taxpayer, and you don't need to go into it. But with a revocable trust, you continue to pay the taxes. If it's an irrevocable trust, it's different.
But if there's a beneficiary or it's joint owned, you can also get around it that way too.
Around probate?
Yes.
Correct. You can. Now, one thing I will sort of deviate here a little bit and mention, we see this from time to time. People will put a child's name on a bank account on the asset, and what they're thinking is, it avoids probate when I die because it's joint. It'll go right to them, and if I become sick, they can help me manage it. I'm not going to ask if anyone here has done that, but it's not uncommon. It's a horrible thing to do, I have to be honest. I've never had a client do it. Every time I've seen it done, I've tried to talk them out of it. Why is that? If you put somebody's name on an account as a joint owner, they legally own a part of that account. If they have any creditor problems, if they get sued, if they get divorced, guess what? That asset's going to disappear. And I had a situation come up a year or two ago. A woman came in to see me. She was in her late 70s. She had a son who had moved back here from Florida after a divorce to stay with her and help care for her. She put his name on bank accounts so he could help pay the bills. And guess what? He hadn't paid his child support in the state of Florida, and somehow as soon as his social security number went on that account, they found it, they sued it, and the best of luck they were going down to Florida trying to get the money back. So there are other ways to deal with that, so that's something that's very important. So, yes?
If you have a bank account with, I think, transfer on death, that avoids probate right there.
You're exactly right. So that's
Right.
another.
That's a good system.
It is. So with brokerage accounts, so if you have, and that's, I didn't mention that, so that's a big point. If you have a brokerage account that's just in your name, you can place a form of a beneficiary designation on that brokerage account. It's known as a transfer on death designation, a TOD designation. And you can name a beneficiary, and that keeps that probate as well. So that's a good one. Anything else on the trust before we move on? Yes?
Somebody over here mentioned the trust, if you have the trust in joint names, does that kind of avoid probate? If it's, if you had your spouse on there for initial death, if you will?
For what?
If the trust was a revocable trust,
Right.
and you have it in joint name?
So you can, so anything in a revocable trust is going to avoid probate, so it doesn't matter whose name it's in. There are trusts, you can set up a trust yourself. Sometimes we'll set up a trust for a married couple, they set it up together. But for the probate avoidance purpose, if it's in the trust, that's how to probate completely, even if it's just in your name. And then what you would normally do if you're just doing it for probate avoidance is you would create it, you would actually be the trustee of your own trust, which may sound a little funny, but you can do that. It's your trust, you're the trustee. What that means is you're in charge of whatever's in there for the balance of your life. But then you can say upon my death, my spouse, my friend, my children, whoever, someone you pick becomes trustee in your place, and then they carry it forward from there.
So probably a stupid question or something, but if you buy a car or something, John G. Rockefeller Trust buys a car?
It's not a stupid question, because I had somebody ask me that exact question this morning.
Not a stupid guy.
Not at all. And what I told him was, it might be possible to do it. I've never done it. I've never seen it done. There is a very simplified form of probate for certain states, and if all you have is a car and a nominal amount of assets, it's incredibly simple. I don't know if you had a pretty, but it's
I
easy.
did do a car and some sort of stock account.
Right.
And I had to probate it, but if it's under $15,000, it's not a problem.
Right. It's gone up actually now to under 25,000.
Oh,
You're
it's
exactly
25
right.
now?
Exactly right.
When I did it, it was 15, and the asset was like 14.5. So it cost me like $65 to probate. And I had a lawyer standing next to me, whom I didn't know. And I was just asking the questions, and he said to me, if it's under 15, you do it yourself. He said, if it's over, well, you better get over it.
Yeah, he's right. He's right.
Yeah, so it was nothing.
For the small estates, that's true. And so for a car, could you get around probate? Maybe, but it's not worth it because dealing with probate for a car is pretty simple. It's if you have more than that. You know, if you've got $100,000, you've got a house. The problem with probate in part, I mean, Massachusetts, again, they totally redid the laws a year ago. And the idea was to streamline the process. But the problem we have in Massachusetts is a funding problem. The probate court, so if someone dies, their estate goes through the probate court. It's called the probate family court. So it's divorce and death, basically, put in the same court. You know, we've had these budget crunches going on in the economy for the past many years, and so the courts' budgets have been cut and cut and cut. And unfortunately, in the pecking order of the courts, the probate family court is kind of down at the bottom. So they're underfunded, they're understaffed, they're overworked in terms of the volume. It is ridiculous how long it takes to get something through the probate court. So not even for the cost factor, but just for the delay with the families, it's doable. All right, shifting gears a little bit. Durable power of attorney. This is a very simple document. Everybody should have one. Durable power of attorney is a document you create and you name someone to make financial decisions for you. The idea is if you have an accident or you have an illness and you can't make decisions for yourself, you need to designate someone to do that. Your financial life continues. Someone's got to pay your bills and do things of that nature. If you do not have a power of attorney and you become incapacitated, your family may need to have someone known as a conservator appointed. And this is, guess what, going back to the probate court and presenting a petition in the probate court saying that this person's incompetent, we need a conservator. It's very expensive, it's very time consuming, it's invasive of your privacy. They have to get a certificate from your doctor basically saying that you're mentally unfit and present that in the court. It can be avoided by having durable power of attorney. So this is the basic thing everyone should have. And typically, again, what you would do is, if you're married, you typically would name your spouse. You don't have to. If you're not married, or if you're a widow or widower, you know, same idea as the executor. Pick someone you trust. They'll have their hands on the assets. You want to make sure you trust them to do the right thing. But it's an important thing.
You can't name successors, though. That's only in the trust itself.
No, actually, you can have power of attorney. So the question is, can you name successors? And we do it all the time. So you can say, you know, person appoints P to be my agent under the power of attorney. If they can't do it, I appoint C to be the agent in their place. And actually encourage people to name successors because the reality is people set these things up and they don't change them for a long time. So maybe the person you name passes away, gets sick, they don't want to do it. So, no, you definitely can name a backup.
Another question?
Yes, sir.
You were saying if you don't have this, they gotta go to the court and get you declared incompetent or whatever it is. Who decides you're incompetent from the person you trust? Is it the person you trust just says you can't handle it right now? I mean, you obviously trust the person.
No, if you have to go get a conservator appointed, what you need to do is somebody needs to go to your physician, whoever it is.
Yeah.
That physician has to examine you. So if you haven't been examined recently, they need to somehow drag you into the person's office to be examined. The physician then needs to sign something called a medical certificate, where they answer about 40 questions about you. But the basic punchline is you're not competent anymore. And then a family member hires a lawyer who puts that together with paperwork, goes into court, actually has to go in an open court session in front of a judge and make a presentation that John Smith is no longer competent, and here's our medical certificate. And then the court makes the determination, are you in fact incompetent? And if so, we'll then appoint somebody to be conservator.
But if you have somebody under a durable power of attorney,
You don't have to do any of that.
okay, so you're just trusting the other person to make the decision that they can handle it.
That is absolutely right. And that's why it's key to name someone you trust. I mean, you're giving them a lot of authority,
Yep.
so you need to pick someone you really have faith in.
Yeah.
All right. Living will and healthcare proxy. So this is the same idea, but this is for medical decision making. Same idea here. It's a simple, basic document. If you don't have one and you become incapacitated, your family, and I say may, not all, sometimes doctors will just talk to the family, but a lot of times they won't. If you become incapacitated and you don't have one, someone needs to still give your medical provider direction in terms of what to do. So if you don't have health care proxy with them, having to have a legal guardian appointed. Same process. Get the certificate from the doctor, hire a lawyer, go to the court. You want to avoid it if you can. How do you avoid it? Healthcare proxy. It's a document where you name someone to make medical decisions. You should absolutely name a backup in the document. you know, if anybody's gone into the hospital for any kind of a procedure, I mean, they're teed up to do this. It's a federal law that basically mandates when you come in, they make sure you have one. And they'll have a form there for you to sign if you don't. But if it doesn't work that way, if you're home and you have a stroke and you're rushed in unconscious, well, you're not going to be able to sign a form. So it's a simple, basic thing. People should have it. A living will is a little bit different, but it works in tandem with a healthcare proxy. Living wills in Massachusetts are not legally binding. They're purely advisory. You're just telling somebody what you want done, but they don't really have any legal effect. But what a living will says is, if you're incapacitated with no chance of recovery, that you would not want to be kept alive by artificial means. They're not binding, so why would you do it? Well, the reason you would do it is really twofold. One is, the person you name in the healthcare proxy needs to know what you want. And maybe they do, or maybe they don't. Maybe you've had that conversation with them and they know, maybe you haven't, they don't. But the other piece is, you don't want that person you name to make those decisions to think that they pulled the plug on you, right? I mean, you want, or maybe you do, I don't know. You know, you want them to feel like they did what you wanted. I honored their wishes. I didn't decide to do this. So, it's important. It's cheery stuff. The bar is open. Any questions on any of that? Yes?
So you said in Massachusetts, the living will is not something that's around? I mean,
Well, it's interesting. It's kind of like lawyer speak. It's not binding. It is, it isn't. I mean, what it is there's no law in Massachusetts that says a living will has this effect and, you know, therefore here's what it means. There's just no law in it. So we use them all the time. I think I know I've done thousands of healthcare proxies. I've probably done one that didn't have a living will. But so we do them all the time, but it's just that it really doesn't have any legal teeth. But it's, again, one of those things that you need to make sure that you're picking people in the healthcare proxy that are going to do what you want, and then this is a way of telling them what you want them to do.
So it's not non-binding. So if my husband tells me he doesn't want to be put on a machine, I can put him on it.
And he will haunt you forever.
And the other way
Or the
around.
reverse, right?
And
That's
the
what I'm
reverse.
concerned about. Yeah,
So I
exactly.
can do that?
I'd be more worried about what's the reverse.
So if he wants to be on the machine, I can say, well, I'm sorry.
I mean, the doctor is going to take the direction from you, right? The doctor is going to say, what should I do, what should I not do? The healthcare proxy will tell someone.
That's like a DNR then?
See, that's a little bit different. So there are DNRs, which is a do not resuscitate order. That's different. That's basically the hospital saying, don't sue me if I don't give you CPR. You know, that's a form they will have you fill out, or sometimes you have it at home for the EMTs that come and something like that.
Right.
And that's where you're telling them, don't restart me. That's a little different. That basically is liability protection for them. They don't want to come in and find somebody on the floor and not give them CPR and then get sued by the family. So that's
To back up a little bit, I'm
Yeah.
sorry, on the trust, where it says protect assets from creditors, how does it actually protect them from creditors? I worked for a bank and they used to come in and, I don't know how many people had trusts. They
Yeah.
wanted those trusts. And then down the road, everybody said, no, I don't want the trust anymore. I've been told it's not the way to go.
Well, it doesn't protect the asset if it's your own, so we'll deviate it. So we'll go back to the trust for a second. So if you have a trust, it doesn't protect it from your own creditors. So if I set up a trust and I put my money into it, and I have the right to get it back, in Massachusetts, I get no protection from creditors. In some states, you can do that. It's called self-settled trust. You created it. You can put things in. Massachusetts is clear. You create it. You put your money into it. You can get your money back. You get no protection from creditors to get it. This is more basically for your children or for others. So I set up a trust for my children. I put money into it. It's protected from their creditors. Any other questions on the living will or health trust? Yes.
I thought that if EMTs came to your house, that they did not recognize a DNR. Is that true?
I do know. I used to be an EMT. It had to be we did recognize the DNR. Unfortunately, it had to be updated every 30 days. And most of them were not. And when they would show me something that was 4 or 5 months old, and I'd say, I'm sorry, but I have to do CPR. So, yes. So we did recognize them, but they were not, they were out of date, so. Maybe it's changed, because I haven't been an EMT now for a dozen years, but in my day, it was 30 days.
Yeah, I know recently, in New York, a person passed away, and they had done I guess, the healthcare proxy and all of that, but she couldn't find it. And the EMTs came, and he wasn't supposed to be resuscitated, but they said she couldn't find the paper. So legally, they had to do it. Yeah.
Put it on your refrigerator.
Yeah, where are you supposed to put it?
Along with all the others who don't.
They can work with the paper.
Stay put the foyer.
Yeah, but somebody's gonna read.
Yeah, so the DNR is important, so it is a little different than the health proxy and the living will, but it's important. Okay. Yes, sir.
On a health property, you can't use it unless it's activated by the doctor. Do you know that?
That's exactly right. So with
A
a
lot of
health,
people don't know that.
so a health proxy, in order for it to actually work, the doctor has to certify that you're not able to make medical decisions for yourself. And they actually have to write that onto your medical chart. So if you're in the hospital, the doctor's not going to listen to the healthcare agents until the doctor said, no, you can't speak for yourself. That's right. And that's good. And that's what you want. Yeah. Okay. Declaration of homestead. So if anybody owns their home, whether it's a house, a condo, or apartment, whatever it is, you should have a declaration of homestead. And this is one of the few things that you can do yourself. What this does is it protects up to $500,000 in equity and credit against your creditors. Frankly, you probably never need it, but if you do, it's good to have. So it's a shield. You can only put it on your primary residence, so wherever that is. It's literally a one-page form you fill out. Just, I hereby declare a homestead. Go to the registry of deeds. They have pre-printed forms. There's like a $35 reporting fee. You put it on. You get the protection over the house. I don't quite understand why in Massachusetts they don't just say if it's your primary residence you get the protection. But that's not the law. You have to know about it. You have to fill out the form. You got to pay them the $35 reporting fee. If you do that, you get the protection.
Excuse me, I heard that it has to be updated because we've lived in
Yeah,
our
we've done it
home
more
for
than
20
once.
years. And we had to go, our neighbor had to go in, she said, and do it again.
How long ago was that?
Well, we've been there 20 years, so maybe 10 years in, she went and she did it more than once.
You don't now. Here's what used to happen. There used to be an issue as to whether or not if you did a refinance of the mortgage, whether or not that would revoke your homestead. So you buy a house, put a homestead on it. The homestead doesn't protect you against the mortgage, right? So the homestead only protects you going forward. So if I buy a house and I have a mortgage on it, and then I put a homestead on it, well, it doesn't protect me against the mortgage because that was there before my homestead. But what if I buy the house, get the mortgage, put the homestead on, and then 6 months later refinance my mortgage?
Which is what we're doing in
Yeah. So does the refinance revoke the homestead? And for a long time in Massachusetts, this was a total mess. Nobody knew the answer. The law, maybe it did, maybe it didn't. A lot of the bank's attorneys put in a statement saying the homestead's revoked for all purposes, which was completely stupid. I mean, what it should have said was it's revoked relative to this mortgage. So it was a bit of a mess. So the state revamped the homestead laws about 2 years ago, and now it's crystal clear in Massachusetts that a refinance of a mortgage, no matter what the paperwork you sign at the bank says, does not revoke that homestead except as to the home. So the answer is you don't need to keep redoing it. That said, if you had any questions that you know you do anything in the past that might mess it up, because for example, if you change the deed, if the husband and wife own it together and they put a homestead on the house and for whatever reason they take one name off the deed, something like that, that can affect the homestead. But generally, you've got a refinance should make that. Yes.
And is there a paper you keep to show that you have that? Do they give you something?
What they normally do is they take it, they stamp it, it shows, you know, what book of names, book of pages, the registry of deeds, they give it back. And everything's online too. If you're computer savvy, if you go to the registry of deeds, you know, you can actually look yourself up by name or by address and see what's online there. You have, you know, if you're worried about it, it's probably worth a trip in there to look.
Definitely, thank you.
On the deeds business for a house, if, the spouse is deceased, does it have to be changed then to the one name, the surviving spouse, or can it be left in the two names?
So the question is, if husband and wife own a house together and one of them dies, do you have to do a deed to put the survivor's name? The short answer is no. What you normally do is if they owned it jointly, so it's joint property, so on the death of the first owner, it goes automatically to the surviving joint owner. But what you need to do is you need to get certain papers on record of the registry of deeds. So if you later try and sell the house, the buyer knows that it's happened. So what you do, and again, you want a lawyer to help with this if you need it, but what you do is you file a copy of the death, certified copy of the death certificate with the deed. Massachusetts has an estate tax, which I'll talk about in a minute. And there's an automatic lien for estate taxes that goes on the real estate when someone dies. And so you need to get that lien released, and there's some simple paperwork for that too. It's not, none of this is a big deal until you go and try and sell the house. But then a buyer is going to be asking for these things, so it's better to do it up front. And it's a pretty simple thing. So I'm going to be very brief in the next point, estate taxes. So there are estate taxes out there. If somebody passes away and they're leaving assets to someone, some portion of that is going to go to the government in the form of a tax. There's a federal estate tax, there's a Massachusetts estate tax. The first important point is if you are married and things are, you die and things go to your spouse, it doesn't matter what the numbers are. No estate taxes do. Massachusetts is federal. You can have $20 billion and if it goes to a spouse, you're not going to pay any taxes. They'll get their money when the second one goes. It's the way it works. So estate taxes are only an issue if things are going to someone other than spouse. And then the question is your estate big enough that you're over these thresholds? Now, federally, for all the chatter here in the press, less than 1% of the people in this country pay the federal estate tax because the exemptions are so high. Currently, each individual can leave $5,250,000 for your federal estate tax. So a married couple, $10.5 million. If you're below that, you don't have to worry about the federal estate tax. Massachusetts has a lower threshold. It's $1 million. And so if you're over $1 million, then you'll pay an estate tax. And you know, living in this part of the country, a lot of people who don't think they'd be over that are, because it counts everything. You have real estate, they count that. If you have life insurance, they count that. Retirement accounts. Literally every single asset you have counts. So shoes in your feet, everything. So it's just something to be aware of. It's out there. Yes?
I looked at a question. Not that I got any of those kinds of money, but you were saying if your spouse, it goes to your spouse unlimited.
Mm-hmm.
But then if somehow, you initially said like in Massachusetts $1 million, so there's like $2 million. But if you die, your spouse is, if you had a $2 million estate,
Yeah.
your now spouse now has $2, so it should get taxed, right?
Yeah, and you don't actually have two for a couple, so it's funny.
Okay.
That's
It's
a little more in the weeds, but
That's kind of where I was. Okay.
yeah. So for federal purposes, the exemption used to be you had a $5,250,000 exemption. For Massachusetts, it's a break point. If you're over $1 million, they tax you on everything. If you're under $1 million, they tax you on nothing. So if you have a married couple, let's say each had $1 million, just for way of example. The first one dies, everything goes to the surviving spouse. There's no taxes that went to a spouse. But now the survivor has $2 million. And his or her death, they're going to pay tax on everything, the whole $2 million. If instead the first one died, had $1 million, and left $1 million to their kids, to their neighbor, whoever, because it was just at $1 million, there's no tax due on the first death. Now the survivor only has $1 million, there's no tax for that. So it's a little, it's probably more in the weeds than we need to get.
So you could split up your $1 million among 5 people, and they wouldn't have to pay a tax?
No, so the estate tax looks at the person leaving the money, not the person getting it. So if the person who dies, you look at them, and you take a snapshot as of the day of their death, and basically say, what would they work on the day they died? If it's over $1 million, and it's not going to a spouse,
The estate pays the taxes
then the estate pays the taxes.
before anybody gets any money.
Correct. And if people, for anybody who's over that number, there are some things, this is another place where a trust comes in. A lot of times with a married couple, let's say they have $2 million and they're worried about the estate taxes. Well, they can create a trust, and when the first one dies, have $1 million go into the trust, then go to the spouse, if you used up their $1 million exemption, the spouse can be a beneficiary of that trust, get money out if they need it, but legally it's not their money. And then when the survivor goes, he or she has less than that magic $1 million number, no tax in their estate, the money in the trust goes through the kids. So there's shelving.
So we should take another trip and spend it.
That's the
Exactly.
best. That's the last check.
I'm taking the first trip to collect it.
It's 40% federally. Massachusetts is a graduated rate, it tops out at 60%.
Yes.
Federal state tax used to be 55%. And it used to be, when I started practicing 13 years ago, the exemption federally was $600,000. The top rate was 55%, so it's a horrendous Yes.
If a, perfect case, if a husband dies and the wife wants to avoid state taxes, she can renounce part of the inheritance, and then it would go to a child.
So this is known as a disclaimer, you were
Yes,
correct.
disclaimer.
So husband and, let me just repeat it so everyone else knows what we're talking about. So husband and wife, husband dies, he leaves everything to his wife, let's say they have kids. She doesn't want to receive it all because then she'll be over those magic numbers. You don't have to accept an inheritance from anybody, so you can do something known as a disclaimer saying, I would have received everything because my spouse died, but I don't want it all. And so I disclaim part of it. And there's formalities and details as to how you do that, but if the survivor does that, then whatever portion of assets they've disclaimed goes where it would have gone if they both died at the same time, so here are the kids. That's kind of, we call that sort of after the fact plan.
Yeah, it's sort of deathbed estate planning.
Yeah, exactly.
Is it a practical alternative?
You know, when I say it's after the fact planning, it's just that. I mean, you don't really want to rely on that up front, but it is, we do that from time to time if people haven't set things up.
Okay, it can be made to work.
It absolutely works.
And can you leave it to more than one person then to, break it out?
If you do this disclaimer,
Yeah.
it depends what your estate plan says, because it goes, if you disclaim it, it goes where it would have gone if you had died first. So let's say the husband's will says everything to my wife, if she doesn't survive me, 3 shares to my kids.
Right.
Well, if the wife disclaims everything, it goes 3
It
shares
goes
to the
3
kids.
shares. Uh-huh.
If she only wants to go to 1, she's out of luck, it's gonna go with the will says.
Mhm.
So she doesn't get any?
No,
Only what she disclaimed.
She disclaims however
She
much she
disclaims
wants.
so much.
She can disclaim everything she would have received, some amount, she can
Okay.
define how much.
I have a question to back up again, I'm sorry. On this declaration of the homestead, does that protect us from going to a nursing home?
Nope.
Protect the house at all?
No.
Doesn't?
Question is the
Nothing does.
homestead protect you from nursing home? I'll come to that next, it does nothing to protect you.
Long-term care, Ken.
Yep, long-term care is one way to do it. So why don't we talk about that a little bit? So, and this I'll be brief, and we could probably spend a whole afternoon on this, but long-term care. So there's Medicare and Medicaid. Medicare is, the long-term health insurance. Medicaid is a needs-based program that will pay for medical care, nursing home care, if you don't have the ability to pay for it yourself. In order to qualify for Medicaid, you have to be financially eligible because it is a needs-based program. It's not designed to be there for everybody. It's designed to be there for people who can't. It is welfare, exactly. If you apply for Medicaid, there are asset limits. You can only have so much money. There are income limits. You can only have so much income. They're pretty limited. The person going into the nursing home can only have $2,000 worth of assets and about $60 a month worth of income. The person staying at home, if it's a married couple and only one is going, can keep is around $113,000 of assets, plus the house. If they own a house, keep the house plus the $113,000. And the person home can keep all of their own income. But anything over that, house plus the $113,000, that's a rough number, the $113,000, has to be spent on medical care before Medicaid will pay. So it's, again, it's a needs-based program. So how do you protect this? A couple different ways. Long-term care insurance, if you can afford it, it's great. The problem is, by the time you start really needing long-term care insurance, most people, frankly, are at a point in life where it's cost prohibitive. But if you're worried about this issue, it's worth talking with someone, a good, honest long-term care insurance broker. They'll be happy to quote it out for you and tell you what it would look like, and then you can decide if it makes sense. But that's certainly something to consider. People think I can just give things away, so I'll qualify for Medicaid. You can't do that. If anybody applies for Medicaid, on the application is a question, have you made any gifts in the past 5 years? And if you've done that, you're going to be ineligible for Medicaid for some period of time. So when people are doing planning, this is, you know, you need to do this in advance. The other thing, I don't know if people have heard this before, or in seminars or read articles, there's a lot of financial planners and lawyers out there that, you know, spend a lot of time working with people to give things away so they qualify for Medicaid. And I'm going to get up in the soapbox for about 2 minutes and I'll move on. I'm kind of skeptical of that because it's not really protecting you. Let's say it's a married couple, husband and wife, and then kids. All this Medicaid planning, it's not protecting you, it's protecting your kids and their ability to inherit your money. Now, if you have a child that has a, you know, a special need or something like that, where they can't care for themselves, they need your money, all right, that's fine. But if, you know, you've raised them, you've educated them, you've got them off the payroll, so to speak, you know, what you're doing when you do this Medicaid planning is it's all aimed around you giving stuff away now. So you don't have it when you have to apply for Medicaid. But guess what? You don't have that money to live on after you've given it away. So and it's just benefiting kids. So I'm skeptical of doing that. I mean, one thing, you know, some people do, and a lot of times it is a sort of a painless thing. Let's say you have a house and you live in this house forever. You're never going to sell the house. You're positive of that. You're never going to want the equity in the house to do anything with it. What some people will do is they'll create an irrevocable trust. We'll come back to the trust. This is an irrevocable trust. Once you set it up, you can't change it. If you put anything into it, you can't take it back. It's sort of a lockbox. Some people will create an irrevocable trust and then put their home in the trust. And the trust can say they have the right to live there for the rest of their life. Assuming 5 years goes by, if there's ever a need to then apply for Medicaid, the house is protected. And I guess I can see people doing that because if you're never going to tap the equity in the home anyways, you're not giving anything up. But when people start talking about putting in cash, brokerage account, bank accounts, those kinds of things into these irrevocable trusts, I just really think you need to think about, you know, you may need that money to live on at some point in the future. And if you do have a special needs child or something like that, and that's what you're worried about, and that's why you're doing it, there's all kinds of other things you can do. The rules allow for that. So, I'll get off the soapbox, but that's all. So is everyone cheered up? So that's all I have. Any questions? Or?
I do, about
Yes.
this 14,000 annual exclusion gifts, that's for each one of your children?
So let me, thank you, I didn't mention that. So for the estate taxes and the gift tax, so there's an estate tax, you die, the government's going to take a piece of the money. There's a gift tax. If you give away more than a certain amount in a year, you may have to pay a gift tax. There is this thing known as an annual exclusion. So every individual is allowed to give away, and people have $10,000, maybe that's the magic number, because it goes there for much time. It's now 14,000. So you can give away $14,000 to as many different individuals every year as you want, and you don't have to report it to the IRS, it's nothing. So you can walk down the street handing out $14,000 checks to whoever you want, and it's, you know, it's a non-issue. Now that's different than for Medicaid. I want to put the two together. That works for taxes, it doesn't work for Medicaid, but for taxes you can do that. Now if you give away more than that, does it mean that you owe taxes? No, it does not. Because in addition to, I said there's a $5,250,000 state tax exemption. Well, you also have a $5,250,000 gift tax exemption. So if you give, let's say you give somebody $20,000 in a given year, it does not mean you owe any tax. What it means is you have to file a gift tax return and tell the IRS that you did it. But until those gifts that you made over $14,000 add up to more than $5,250,000, you don't have to pay a gift tax.
For one person?
$5,250,000
Each person you give to?
No, you, so this again looks at you, so you can give away. Well, so that's before you have to report it. If you give more than $14,000 to any individual, you have to report that gift. But until the gifts that you have made, however you've made them, over that $14,000 amount to each person, are more than $5,250,000, you don't have to pay any gift tax. So last year, for example, there was concern that the estate tax rules are going to change in a very bad way. We had a lot of our wealthier clients give away, you know, $5 million to various people, and they had to file a gift tax return. I know. I tried to get into a few of them. You don't have to pay any tax until you go over that amount. So
The receiver has to pay tax,
No.
not even.
Oh, they don't either.
No, if someone, the way the gift estate tax system works, if there's any tax due, it's paid by the person making the gift, not the person receiving it. So let's say somebody was super wealthy and they gave one of their kids $10 million. The person who gets the $10 million pays not a penny of tax on that. The person who makes the gift is going to have to pay a gift tax for having made the gift.
But if it's under the 14,000, the receiver does not have to declare that as
He
income or
doesn't
anything like that?
They don't have to declare it as income if it's $1 million. You could give somebody $1 million, they do not have to declare it as income at all.
I'll stick at 14.
Stick with 14, all right. I don't know your kids. But the 14 break point is just that you have to tell the IRS about it. That's all that is. If you go over 14, you have to report it to
So
the
why do you
IRS.
have to if you're not gonna pay
Yeah.
taxes?
Right.
Why do they have to know?
We don't trust them, you
Five
guys.
years.
Well, they wanna know if you've gotten up to the
They
high
want to
end.
know, have you gotten over the 5 million break point?
Oh.
And 5 million is lifetime.
It is lifetime, and it also ties into the estate tax. So what the system basically says is, look, and NAS doesn't have a gift tax, so the gift tax is all federal. Federally, what the government is saying is, look, you can give away $5,250,000. I don't care if you do it during life or do it at death. This is the amount you can give away. So let's say you gave away $1 million during life. At your death, your exemption is not $5,250, it's $4,250, because they know you've used up $1 million of it. So that's why they want you to report it.
Do you report it on your income tax?
Special form, there's a special, it's a form 709. There's a gift tax return
Oh,
that is just for this. So if you ever do make a gift, talk with your CPA or an attorney, they can prepare it for you.
Is it better to put it into a
Well, I
trust?
think my kids are gonna be lucky.
I gotta give you a lawyer's answer, it depends. I mean,
You're the lawyer.
no, but it depends. It really depends on what your situation is and what you're trying to achieve. For some people it is, for some people it isn't. It's hard to say just generally it's better to put it in.
Well, if you don't have very much, you want to save every penny you can for your kids, so
Absolutely.
that's what he's thinking, I'm sure.
One question that you don't have in here, and I don't know if it's your expertise or not. The business of reverse mortgages, just to take equity out of your house and so forth. Is this something that you would think would be a good thing or not?
I have to be honest, I don't know a lot about reverse, I'm probably the wrong person to ask. I think the people who sell them think they're great. Honest answer is I don't know.
you have to ask that movie star that advertises on TV.
They're all
You
moving.
trust him? You trust him? He's only a spokesperson.
I'll stick around for a minute if you
And
have
he's
any
a
other questions,
senator,
but
too.
otherwise, thank you.
Thank you very much.
Go enjoy the bar and the cookout.
Thank you very much.
Thank you.
Hi, this is Pete Peterson. You are watching Medfield.tv.
Access to our community.